Yes.
Which page?
In the index itself.
No, in the index somehow.
Oh, it's
Wrong
sorry.
page has
It's the
come.
first volume. Your Lordship has the index. No.
No, we.
Oh, I'm so sorry.
No, first volume is a complete full index.
No, I think my Lord's copies. Second volume. My Lord's copies don't have it.
Only same page.
First volume has the full
First
index.
volume will go on.
Oh, yes. Okay.
We are having it.
Sorry, yes.
Sorry. That's the first volume's index. It has the index for all three volumes.
Yes.
So item 21 is what I just referred to. List of instances in the caravan article. Then item 23 is Indira Gandhi. Your Lordship may just note there itself, paras 213 and 239 and 345.
Yeah.
Then Mohinder Singh Gill, which is the immediate next one.
24.
Well, a few others. Paras 12 and 39 to 41.
39 to 41.
39 to 41.
Yes.
There's also concurring minority, which has conclusions of the majority are at 92. Then minority 105 to 107 and 113. Then Manoj, item 26, Kanhailal, is paras 9, 16 and 17.
Para 9.
16 and 17.
Yeah.
Sensation, there are a series of paragraphs, I'll read that for us, but it's largely 10, 11, that's item 29, I'm sorry, item 29, PN session, 10, 11, 16, 18 and 19. Item 31, Mullah, special reference, that's paras 27, 75 to 77, and para 80. And item 32, Association for Democratic Reforms, para 45.
Yeah.
Mullah. Now, my lords, I'll just address briefly on these 4 points that I want to add. The first is with reference to the committee for appointment. Your lordships have, and I'm using this parallel, the parallel which has already evolved and exists for 2 sets of institutions. For the judiciary, that parallel started with the second judge's case, the creation of the collegium, its re-emphasis in the NJC judgment. NJC judgment, my lords, is not part of this compilation. That's Supreme Court Advocates on Record Association. That's 2016, 5 SCC, page 1. These judgments together, and I may read 1 or 2 paragraphs, but these judgments together, I mean, the lordships have all read this many times, effectively say, apart from interpreting words in the constitution, consultation meaning concurrence, creation of a collegium, a fact that doesn't exist in the constitution but created as a mechanism to take the constitutional goals to a particular end, an end which is independence of the judiciary. There is a very clear parallel there, and the emphasis has come back by saying independence of.
I think a compilation contains the judgments also.
Not NJSC, not the NJSC judgment, but your lordship may not trouble yourself, not this moment. I just broadly set the framework. Therefore, what are the things that are required for me to draw this parallel? One, there has to be a fundamental norm which goes to the ethos of the constitution. Independence of the judiciary there, free and fair elections and democracy here. A vacuum which exists in the constitution with reference to process of appointment. There was a particular kind of process where the may even now, as the government does make arguments saying that really there is no vacuum, interpretation shouldn't have been made. In this case, there's a very clear vacuum. There's nothing in the constitution which assesses on how that appointment will take place. Third, the kind of roles that are discharged by these institutions. Is it a role which is independent? Is it a role which provides a very integral check and balance into other institutions? Which I don't think we need to regurgitate the fact that that is true of the judiciary and it's true of the election commission. Many of these judgments and those citations I've given your lordships, particularly MS Gill and that Gujarat special reference. Those two judgments, as far as your lordships will read, will tell your lordships how the powers of the election commission are wide, the powers of the election commission are of a nature of high sanctity within the constitutional structure. If that is so, and that holds true for the judiciary, the same level of protection, ironclad protection, is required for them as well. And I am completely in agreement with what fell from Justice Rastogi. We won't go into instances. Let's keep this completely clear of instances. You may have great individuals, like Dr. Ambedkar said in his closing speech in the Constituent Assembly. Finally, it is about the people and their character which will drive the institutions under this constitution. So you may have excellent chief election commissioners and election commissioners. You may have weak ones. You may have ones who are influenced. The idea here is not to look at the individual, but to look at the institution and to say, let us have a system in place which will insulate and protect that institution from the vagaries of the political class, from the vagaries of a ephemeral executive that will come into the saddle based on a bunch of votes at a particular point of time. If that is so, this one parallel, which your lordship will find with the second judge's case and what is now the fourth judge's case, is one. The second parallel to that, and which is why I'll trouble your lordship with the book, is Vinit Narayan. Because Vinit Narayan's history, even though it came from the Jain diaries and it having come from a terrorist who was arrested, etc., it took a completely different direction. If your lordship will have that judgment, this deals with the other institution, the CBC, the CBI director, excuse me, and the director of the ED. This is 1998, 1 SEC, 226. It's not in the compilation. 1998,
226.
1 SEC, 226. Mr. Anil Devan was the amicus in this case, and recently there's a foundation in his name with Shyam Devan and others, and they've started a series of very interesting podcasts where they discuss each case, each 2 or 3 important cases of Mr. Anil Devan's life. They've started with this, and it's a long 45-minute podcast dealing with many aspects of the history of this case, how it evolved, how it went through, and what its influence has been in the years that have come. If your lordship will see para 26.
You are in practice when Mr. Anil Devan was in active practice.
I have instructed him as well. I'm not that young.
I've seen him.
Yes. Para 20
taxations.
No. A very fiercely independent man. He appeared for Mr. Ramjet Manani and Ramjet Manani in the black money case. And they used to, it was fascinating for young lawyers like us to see the two of them, client and lawyer, loudly arguing. And Mr. Devan, I remember in this very courtroom once saying, I'm your lawyer, you keep quiet.
There's a bit of a Mr. Shankar Narayan.
Yes.
This was during the end years of Mr. Devan's life.
Yes.
He was on a wheelchair.
Yes.
I had gone to the Akshara Theatre
Right.
near Aramal.
Yes, yes.
So he was brought in a wheelchair because it was in commemorative Jalabala Vaidya and Gopal Sharma. So, of course, I said hello to him. I was a judge in Guwahati. And if you visit Akshara Theatre, you mentioned 2 persons.
Yeah.
On the left-hand side of the wall, Ram Jethmalani's name is written there. So he must have sponsored
Oh, you must have.
the
Yes.
creation of that theatre. Jethmalani and Anil Devan I mean, when he was perhaps not able to move, he had gone to watch a performance.
Fantastic. Well, it's good to have that kind of balance. Mr. Ashok Desai used to keep telling all youngsters that don't just immerse yourself in law books, get into culture, read fiction. Very important.
Yes.
So it's para 26 of this. 26, the page 255. This is dealing with the internal committee that had been set up. If I can just read this part. The IRC is a body constituted by the central government itself as a result of its perception that the constitution and functioning of the CBI, CVC and Directorate of Enforcement require a close scrutiny in the background of the recent unsatisfactory functioning of these agencies with a view to improve their functioning. The view taken by the IRC is a reaffirmation of this belief shared by everyone. The preface to the report indicates the reason for the constitution of the IRC and says that in the past several years, there has been progressive increase in allegations of corruption involving public servants. Understandably, cases of this nature have attracted heightened media and public attention. A general impression appears to have gained ground that the central investigating agencies concerned are subject to extraneous pressures and have been indulging in dilatory tactics in not bringing the guilty to book. The decisions of higher courts to directly monitor investigations in certain cases have added to the aforesaid belief. There can thus be no doubt that there is need for the exercise we were called upon to perform, and which has occasioned consideration of this crucial issue by this court in exercise of its powers conferred by the Constitution of India. The conclusions reached by the IRC and the recommendations it has made for improving the functioning and thereby the image of these agencies is a further reaffirmation of this general belief. There can also be no doubt that the conclusions reached by the IRC and its recommendations are the minimum which require immediate acceptance and implementation in a bid to arrest any further decay of the polity. It follows that the exercise to be performed now by this court is really to consider whether any modifications or additions are required to be made to the recommendations of the IRC for achieving the object for which the central government itself constituted the IRC. We are informed by the learned Attorney General that further action on the part of the IRC could not be taken so far because of certain practical difficulties faced by the central government, but there is no negative reaction to the report given by the central government. Now, this is the background, Manoj. Please come to para 49. Dealing with the powers of this court. 49. 48 I'll take as read, Manoj. 49. There are ample powers conferred by Article 32 read with Article 142 to make orders which have the effect of law by virtue of Article 141, and there is mandate to all authorities to act in aid of the orders of this court as provided in Article 144 of the Constitution. In a catena of decisions of this court, this power has been recognized and exercised, if need be, by issuing necessary directions to fill the vacuum till such time the legislature steps in to cover the gap or the executive discharges its role. It is in the discharge of this duty that the IRC was constituted by the Government of India with a view to obtain its recommendations after in-depth study of the problem in order to implement them by suitable executive directions till proper legislation is enacted. The report of the IRC has been given to the Government of India, but because of certain difficulties in the present context, no further action by the executive has been possible. The study having been made by a committee considered by the Government of India itself as an expert body, it is safe to act on the recommendation of the IRC to formulate the direction of this court to the extent they are of assistance. In the remaining area, on the basis of the study of the IRC and its recommendations, suitable directions can be formulated to fill the entire vacuum. This is the exercise we propose to perform in the present case, since this exercise can no longer be delayed. It is essential and indeed the constitutional obligation of this court under the aforesaid provisions to issue the necessary directions in this behalf. We now consider formulation of the needed directions in the performance of this obligation. The directions issued herein for strict compliance are to operate till such time as they are replaced by suitable legislation in this behalf. Para 51 lists out the various cases where directions, this is before 98, all directions had been issued with reference to the guidelines under immigration, foreign adoption, of course Vishakha and others. Vishakha is laid down, the extract is there on the following page. And para 52, as pointed out in Vishakha, it is the duty of the executive to fill the vacuum by executive orders because its field is coterminous with that of the legislature, and where there is inaction even by the executive for whatever reason, the judiciary must step in exercise of its constitutional obligations under the aforesaid provisions to provide a solution till such time as the legislature acts to perform its role by enacting proper legislation to cover the field. On this basis, we now proceed to give the directions, etc. Para 54 is interesting because your lordships adopted these standards in public life. It is a similar perception in England, para 54, which has led to the constitution of a committee headed by Lord Nolan on standards in public life. In volume 1 of Lord Nolan's report, the general recommendations made are, and they have laid down the 7 principles, small number 5 if your lordship sees, principles of public life. The general principles of conduct which underpin public life need to be restated. We have done this. The 7 principles of selflessness, integrity, objectivity, accountability, openness, honesty, and leadership are set out in full on page 14. Codes of conduct which should be drawn up by all public bodies, independent scrutiny, education. Then these 7 principles are laid down below for those who hold public office. And para 55, the court says, these principles of public life are of general application in every democracy, and as one is expected to bear them in mind while scrutinizing the conduct of every holder of a public office. It is right that the holders of public offices are entrusted with certain powers to be exercised in public interest alone, and therefore the path is held by them in trust for the people. Any deviation from the path of rectitude by any of them amounts to a breach of trust and must be severely dealt with instead of being pushed under the carpet. If the conduct amounts to an offence, it must be promptly investigated, and the offender against whom a prima facie case is made out should be prosecuted expeditiously so that the majesty of law is upheld and the rule of law vindicated. It is the duty of the judiciary to enforce the rule of law and therefore to guard against erosion of the rule of law. Well, it's para 58, eventually, the directions that they give. The first direction is important because it's the first time, despite judgments in the past saying courts don't give directions for framing of statutes, your lordships gave a direction that the Central Vigilance Commission shall be given statutory status, which it was given in compliance with. One previous instance was in Indra Sawhney, where lordship said that the National Backward Classes Commission should be formed for deciding addition and removal from the list of backward classes. There also the Parliament effectively complied by passing such a law, the National Backward Classes Commissions Act. Now, the whole swath of directions, large part of this based on the recommendations of the IRC, another part dealing with recommendations of the amicus curiae as well. So the first one is dealing with CBI and CBC, and the second, which starts at page 271, deals with the Enforcement Directorate. And one interesting part of these directions is that both in this case,
Mr. Shankar,
yes,
this direction has to be given in a collaborative proceeding.
absolutely.
Because legislative exercise is on the basis of majority rule in Parliament.
Absolutely. There's no running away.
Because we direct, we
Correct.
can't say
Yes.
all the MP should vote in a particular way.
Absolutely no. Absolutely no. I don't think the court did that either. I think this is the court's way of recommending that please give it statutory flavor.
Yes.
Because that's the only way you can really have it.
Executive direction also.
Yes. And it's a sign of cooperation that the government did.
This is a collaborative.
Absolutely. Completely collaborative. It was not, there was no question of a mandamus being issued, sir.
What led to it is para 50. So what was the background where the court took a view that why do we need to get into in this mode in para 50?
Yes, I'll read that. I'm great. There is another aspect of rule of law, para 50, which is of equal significance. Unless a proper investigation is made and followed by an equally proper prosecution, the effort made would not bear fruition. The recent experience in the field of prosecution is also discouraging. To emphasize this point, some reference has to be made to a large number of prosecutions launched as a result of monitoring by the court on this matter, which have resulted in discharge of the accused at the threshold. It took several years for the CBI to commence investigation, and that too as a result of the monitoring by this court. It is not as if the CBI, on conclusion of the investigation, formed the opinion that no case was made out for prosecution so that the earlier inaction may be justified. The CBI